Hello everyone, my dear students. Welcome back. This is CA Manichandana and let's continue. So I think we were doing the classification of companies. We completed with classification of companies on the basis of liability, right? Company limited by shares, company limited by guarantee and unlimited company. Good. Are you revising? Are you all revising? You should. You should revise. Or else it will be very difficult to at least understand what's going on in class, right? You have to revise once you finish your lectures. That's the most important, uh, the first and the foremost thing a CA students should develop as as a habit. Once they finish the class, the most important thing they have to do is they have to sit. It doesn't take much of your time, maybe maximum 15 minutes max, or maybe 15 to 20 minutes max. So you have to make sure you have to give that amount of time once you finish your class, obviously based on the number of hours you have attended. Like if you have attended if like attended 2 hours of lecture, or probably yeah, you would need around half an hour to 40 minutes of time for your revision. But if it's a 1 hour class, max 20 minutes would suffice. And children, please make it a habit. It's this is the first thing you all have to learn. Without this, it's very difficult for you to understand the next topics, because most of the topics have relation. They relate to the previous topics, and also it's very difficult for you to remember. I have told you multiple times, if you do not revise even a movie, if you have not watched it twice or thrice, it's very difficult to remember what happened in the movie in a sequence. So we need not talk about subjects, and when it comes to studies, you don't even have to talk about it. Something which you like, when you have so much of interest, that only you cannot remember or recollect if you have not watched it twice or thrice, right? But the same thing applies for your studies as well. Like if you just hear me once, or when you just listen to me once in class, not hear, sorry, you should not hear your class, you have to listen to your class. There's a major difference between hear and listen. Okay, now I cannot get into English, but you have to listen with concentration. Hear is nothing but you hear, whether you retain or not doesn't matter, right? But when you listen, you have to listen, meaning you have to with all the concentration, you have to put all your ears into what ma'am is trying to tell, and you have to retain whatever I tell you, right? That's the basic difference between hear and listen. Okay, all of those things aside, I want you all to revise on a daily basis. Okay, only then you will be able to understand what's happening in class. Can we continue? Okay, so yeah, what I was telling you is we have completed classification of companies on the basis of on the basis of liability. Now let's start off with the classification of companies on the basis of members, right? Okay, so let's just read what are the companies under this subheading. Okay, the first one being one person company, then comes the private company, right? And yeah, private company, then comes small company. Small company, see, OPC and small company are nothing but private companies. Small company and OPC are also private companies only. And next comes public company, right? Okay, let's do every single topic with let it take its own time. There is no urgency. Let's understand. See, without understanding, you just mugging up doesn't help, right? Okay, let's do it one by one in detail. Now, let's start with one person company. Let's start with one person company. Okay, the name itself, children, one person company. One person company. Yes. What does this mean? So there is only one person in the company. Okay, good. But who is that one person? Is he a member, or matlab, shareholder, or is he a director? A company which has one member or one shareholder is called a one person company, or the one person company. Is it like, okay, let me frame it in a better manner. See, obviously you all know the company here, shareholders are different and the management is different. Basically, who are the shareholders? Shareholders or the members are the owners of the company, right? They are the owners of the company. Management, who manage the business of the company, who are they? The directors, right? See, you make one thing clear. Make one thing clear. What is that? Is one person company is a company where there is only one member or there is only one shareholder. Getting it? So ownership, 100% ownership is with one person, is with a single person. So when it comes to management or directors, this does not apply. So directors maximum 15, maximum 15 is the limit. The one person company can have 15 directors, minimum one director, maximum 15 directors. So please don't confuse yourself. One person company means one member, means one member. See here, let me read. Section 2, subsection 62 of the Companies Act 2013 defines one person company as a company which has only one person as a member, not as a director. Getting my point? This is the basic thing which you have to make it clear. Say someone wants to incorporate a OPC or someone wants to incorporate one person company. When you become a chartered accountant, you cannot have, you should have only one director. No, it's wrong. The business can be run by 15 directors, no problem, but the ownership or the member must be only one. This basic thing is clear? Yes, right. Okay, so this one person company, this concept, children, this was introduced in the Act 2013, the Companies Act 2013. The Companies Act 1956 did not have something called as one person company, right? That is what they are trying to tell you, right? See, the Companies Act 2013 introduced a new class of companies which can be incorporated by a single person. Ma'am, why ma'am single person? What is the need of, they can incorporate a proprietorship? No ma'am. Proprietorship you all know. Yes, proprietorship, you have idea, right? If you have seen my first class, I've told you what is a proprietorship. So if I want to start a business on my own, I do not, I do not trust anyone, or I don't want anyone else in my business. Rather, I only want to start my business. But what happens is I only own my business in a proprietorship concern. And here the liability of the proprietor will be unlimited, meaning what? Meaning the personal assets of the proprietor will be attached if there is a if the proprietorship incurs losses, right? Getting my point? But here in OPC, this is a company. So go back to the features of the company. Features of company: limited liability. Yes or no? So okay, limited liability. Yes. So if I want to start a company, but I do not want anyone else, I alone want to start a business. I want to start a company. Getting it? So, but I want limited liability. I do not want my personal assets to be attached, right? If the company incurs losses, if it gets insolvent, obviously I do not want my personal assets to be attached. So this concept was being introduced in this Companies Act 2013, wherein it provides, see, OPC is a separate legal entity again because it is a company with limited liability, of the member. Whereas in case of sole proprietary, the liability of the owner is not restricted and it extends to owner's entire assets constituting of official and personal, meaning the business assets will also be attached. That is there. But even his personal assets will also be attached in case of sole proprietary concern. So removing the negative of the sole proprietary concern, but taking the positive of the sole proprietary, that is only one person can start a company. What we are doing, there is a new concept called one person company, wherein you can incorporate and do your business with you as a sole member in that particular company, and you enjoy limited liability. Clear? Yes, the concept is clear. Yes or no? Right. Fine. The procedural requirements of an OPC are simplified through exemptions provided under the Act in comparison to other forms of companies. Now, what do you mean by this particular line? Children, when it comes to companies, obviously the compliances are pretty much high. right? Why? Because obviously Companies Act 2013 is applicable, section 470 sections. How many sections are there? There are 470 sections in Companies Act. So all of these sections are applicable to companies, right? All of these sections are applicable to companies. But in case of OPC, few exemptions are provided. There are few exemptions provided to OPC when you compare it with other forms of companies. Say, for example, with respect to annual general meetings, with respect to board meetings, there are many exemptions which are provided, because obviously it's a small company. Not small company. Small company has a different meaning altogether, because it is a OPC, right? So there are many exemptions with related to the sections which are given in order to encourage OPCs, right? Good. Fine. Next. According to Section 3(1)(c) of the Companies Act 2013, OPC is a private limited company. Didn't I tell you? Yes, OPC is a private limited company. Obviously, it cannot be a public limited company. What is public limited company? We will tell you. Public limited company is a company which is not a private limited company. This is what the definition which is given in your book. But once you study what is a private limited company, then you will know what is a public limited company. And I also told you in our first class we have discussed, public company is where you ask money from the public, where public money is involved, where all the public are the shareholders of the company, right? Yes, right. Okay, fine. OPC is a private limited company with the minimum paid up share capital as may be prescribed and having one member. Children, again, as may be prescribed. This in law means it will be prescribed as in rules. Okay. Now, what are these rules? You will get a better understanding when we do small company. So I'll tell you what it is when we discuss small company. As of now, as may be prescribed, meaning whatever it is prescribed, that will be prescribed in the rules, companies rules. Okay, you will understand. Just in maybe today itself, we will do small company and you will understand. Okay, fine. So this much is clear. Okay, what did we learn? One person company. It is a kind of new class of company wherein it was introduced in this particular Act, Companies Act 2013 and Companies Act 1956. This OPC concept was not there. Okay. Then one member or one director? One member. Maximum number of directors is 15. Okay, you can have 1 to 15 directors. Directors we are not talking about here. One person company meaning a company which has only one person as a member. He holds entire 100% of the share capital of the company. Clear? Yes, everyone? Yes, ma'am. So, okay, one person company has been introduced to encourage entrepreneurship and corporatization of businesses, and OPC differs from sole proprietary concern in an aspect that OPC is a separate legal entity. In sole proprietorship, no, it's the same. You are starting a business as a sole proprietor, meaning you are nothing different from that proprietorship. It's the same, right? It's not a separate legal entity. But when it comes to OPC is a company. Company meaning the features of the company. What are the features of the company? Separate legal entity. Yes, ma'am. Separate legal entity with limited liability. With limited liability of the member. Limited liability of whom? Limited liability of company, na? No. Limited liability of member. Limited liability of member. Very good. Whereas in the case of sole proprietary, the liability of owner is not restricted and it extends to the entire assets of the proprietor. Okay, fine. So this is fine. Right, okay. Let's start with OPC significant points. OPC significant points. Children, this concept is very, very important. Important meaning it has come multiple times in your examination, but each and every topic carries equal weightage in your examination. Please keep that point in mind. You cannot leave any topic in your examination. See, when a teacher says this topic is important or the other topic is important, you cannot make a selective study. You cannot make a selective study. You have to study 100%. You have to cover 100% of your syllabus in your CA examination. Keep it any level, CA foundation, CA inter or CA final. You have to cover 100% of your syllabus. This is the first and the foremost rule to clear your examination, right? Second, revision, obviously. Fine. Okay. Come to page number 470. Let's start off with OPC significant points. Okay, right. Good. Fine. Only one person as member. You all know one person as member. There's only one person who can be the member of the company. The name itself signifies one person company. Right. Directors, one, na? No. Minimum one, maximum 15. Everyone clear? Minimum one, maximum 15. But when it comes to members, minimum also one, maximum also one. Okay. Is there any minimum capital, paid up capital prescribed? Is there any minimum paid up capital prescribed? No, there is no limit prescribed. Meaning you can start a OPC with just minimum capital, say for example 5,000, 10,000. You can start off a OPC. Right? Fine. Next, the memorandum of OPC shall indicate the name of the other person who shall, in the event of the subscriber's death or his incapacity to contract, become the member of the company. Ma'am, what does this mean? See children, this is basically talking about nominee. This is basically talking about nominee. So in the memorandum of association, ma'am, what is memorandum of association? We will learn in the coming classes. This is basically a document of the company wherein you have all the clauses like name clause, object clause, then capital clause, etc. for normal companies. And when it comes to OPC, there is one more clause in the memorandum of association which will be included, that is the nominee clause. Now, what is this nominee clause? Nominee clause meaning children, say for example, yeah, OPC, there's only one person who is the member of the company. There is only one person who is the member of the company. Now, this person, if he dies, if this person dies, he's dead. Okay. If he dies or his incapacity to contract, ma'am, what does this mean? Children, we will do it in Indian Contract Act in detail, but just for your understanding, say for example, a minor, basically incapacity contract meaning you cannot enter into contract. You cannot enter into contract. Ma'am, example, minor or a person of unsound mind obviously they cannot make reasonable decisions. A person of unsound mind meaning his mind is not working good. Basically, he's not of sound mind, right? So he cannot enter into contract because he'll not be able to make reasonable decisions. Yes or no? Say, so for example, if this particular member, the sole member of the OPC dies or in his incapacity to contract, this person who is the nominee, will become the member of the company, So when you incorporate a OPC, you also have to give the name of the nominee who shall, in the event of the death of the member or in the incapacity to contract of that particular member, this particular nominee will become the member of the company. Clear? Yes, everyone? Yes, ma'am. Okay. Now, the other person, who is this other person? Nominee. This other person meaning nominee. The nominee whose name is given in the memorandum shall give his prior written consent in the prescribed form, and the same shall be filed with the registrar of companies at the time of incorporation of the company along with its e-memorandum and e-articles. Children, it's very simple. It's nothing but, say for example, you are that nominee. Say for example, your friend, say, I'll just show you. This is your friend, okay? This is your friend, say for example, Manja. And what? It's the name of that person. Say for example, his name is Manja. And what is this Manja, ma'am? I think this is the name of this particular person. Okay. He's your friend. Who is he? He's your friend. Yes. Now this friend has given your name as nominee. Meaning, if something happens to Manja, in his place, you will become the member. Yes or no? Now you have to give your written consent, prior consent, telling yes, obviously, right? So you have to affirm that, you have to give your affirmation that I am okay, I will become the nominee of this particular company. Yes or no? Without your permission, how can you become the nominee of some company? Basic sense, right? So see, the other person, that who is he? The nominee shall give his prior written consent. Prior meaning, what do you mean by prior? before starting the before incorporating a company, or before giving the name of the nominee in the memorandum, that the other person has to give his written consent in prescribed form. Now, what is this prescribed form? See, children, when you incorporate a company, there are multiple forms which have to be filed with the ROC. ROC meaning Registrar of Companies. I've also told you this is not Register of Companies. This is Registrar of Companies. He is a person. He is basically a person. It is not a register. It is not a book. Getting it? So this prescribed form. What is this prescribed form? This is INC 3. INC 3. So in this INC 3, what does this INC 3 contain? Basically, it contains the nominee's details, his name. So for example, you are the nominee of the particular company of your friend. Say for example, your name, your address, the OPC name, its address, and your affirmation that you agree to become the nominee of the company, etc., etc. You can see it anytime. Okay, INC 3. So this has to be filed with whom? This has to be filed with ROC. ROC meaning Registrar of Companies. ROC meaning Registrar of Companies. See, prior written consent in prescribed form. Which is this prescribed form? INC 3. There are multiple forms which have to be filed with ROC when you are incorporating a company, and also as and when there are so many compliance requirements which a company has to do basically annually. All of these are there. So there are various forms given to everything, and for this particular written consent, prior written consent, the form prescribed is INC 3. Getting it? Okay. Along with this prior written consent, e-memorandum of articles and e-articles of association. Basically, in electronic, your memorandum of articles and articles of association in electronic form has to be submitted to ROC at the time of incorporation of the company. Clear everyone? See, that is what they're trying to tell you. The other person whose name is given in the memorandum shall give his prior consent, prior written consent, right? Prior written consent. In what? In a prescribed form. What is the prescribed form? INC 3. And the same shall be filed with the Registrar of Companies at the time of incorporation of the company, along with e-memorandum and e-articles. Right? Everyone getting it? Yes. Now, such other person may be given the right to withdraw his consent. Such other person meaning whom? Again, such other person meaning the nominee. Yes. So, see here in the chart, if you can see, this is the nominee, this is you. This is you, right? So you are given an option to withdraw your consent. You may withdraw your consent at any time. If you do not like, obviously you don't like your friend, he is asking you to become something, I to problem between you and your friend. There is some dishum, there is some dishum, and now you can withdraw your consent. You can withdraw your consent. You do not further want to be the nominee of that particular company. Anytime you can withdraw your consent. Getting it? Yes, ma'am. Next, the member of OPC may, the member of OPC may at any time change the name of such other person meaning nominee. Yes or no? Yes, the member of OPC may at any time change the name of such other person by giving notice to the company, and the company shall intimate the same to the registrar. Ma'am, what is this? Come to the chart. See, now your friend Manja, right? He started dating some girl. Started dating some girl. He fell in love with some girl. Yes, his girlfriend. See, this is Manja's girlfriend. Let's name her Manju. Let's name her Manju. Okay, now he started liking this girl. Yes, now what will he do? Now what will he do is he wants to change the name of the nominee. He wants to change the name of the nominee. Now he does not want you. Side. You and all side. Now he wants to bring in his girlfriend as the nominee of his company. Can he do so? Can he do so? Yes, he can do so. So your friend can change the name of the nominee by giving, what should he do? By giving notice to the company, and the company shall indicate the same to the registrar of companies. That is what they have tried to indicate. No, this is intimate. Sorry, this is not indicate. This is intimate. Right? Intimate the same to the registrar of companies. Fine. Okay, see. So the member of OPC may change the name of such other person. Who is that such other person? That is the name of the nominee. He can change the nominee at any time. Yes, ma'am, he can do so. How? By giving notice to the company. He can tell the company that he wants to change the nominee. Yes, and the company shall intimate the same to the registrar of companies. That is nothing but ROC. Basically, the company has to intimate to the ROC. Fine. And any such change in the name of the person shall not be deemed to be an alteration of the memorandum. See, children, shall not be deemed. What do you mean by deeming? What do you mean by deemed? See, in law, when you tell deem, the deeming provisions, meaning it is nothing but the act presumes. The act presumes. Deeming meaning, sorry, act, one second, I'll write it for you. Act presumes. Means it assumes something. Okay, the act itself assumes something. That is the meaning of deemed. Okay, but here what they are trying to tell you, shall not be deemed, meaning any such change in the name of the person. If you have changed the name of the person, before you were the nominee, now his girlfriend is the nominee. Yes or no? Now this shall not be deemed as an alteration to the memorandum. That does not mean you are changing the memorandum. There is something you are altering the memorandum. Simple. Yes, ma'am. Next, important. Okay, fine. Come to the next point. Okay. So the next point, that is, okay, only a natural person who is an Indian citizen, whether resident in India or otherwise, and has stayed in India for a period of not less than 120 days during the immediately preceding financial year shall be eligible to incorporate a OPC or shall be a nominee for the sole member of a OPC. Students, just a small correction here, okay, with respect to the pointers. Okay, just want you to cancel this particular point. There's no point here. This entire line, whatever is there here, na, resident in India or otherwise, will come here. Okay, basically it is just one single line wherein, see, only a natural person who is an Indian citizen, whether resident in India, whether resident in India or otherwise is one condition. See this, okay, you can just cancel this. Okay. Now there are two conditions to be satisfied. This is the first condition, and yes, this is the second condition. Okay, if you satisfy these two conditions, then you shall be eligible to incorporate the OPC, or you will be eligible to become the nominee of the member of that OPC. Now, ma'am, what are those two conditions? Okay, let's see in detail. Fine. See, what is that? First, they are telling only a natural person. Natural person meaning not an artificial person, meaning a company cannot become a member of OPC. A partnership firm cannot become a member of OPC. Clear? Natural person. You, me, all of us can become members of OPC. Now, who is an Indian citizen? Okay, that natural person should be an Indian citizen. So, if you call an African, if say for example, a person from Africa or say a UK citizen wants to become a member of OPC, is it possible? No, it is not possible. Okay, whether resident in India or otherwise. I'll come to this later. That is not of that relevance now. Okay, because there's a small amendment to this particular provision. Okay, I'll tell you the amendment, but for you it's not relevant anyways. Not only for you, for none of us it's relevant now, because whatever was there prior to that amendment is no one actually requires that. Okay, and has stayed in India for a period of not less than 120 days, during the immediately preceding financial year. Okay, what are the two conditions now? One, natural person who is an Indian citizen, whether resident in India or otherwise. Okay, natural person who is an Indian citizen, whether resident in India or otherwise. Okay, that let's keep it pending now. Okay, and children, in law, it's always important whenever you see this word and it means that both the conditions need to be satisfied. This condition also has to be satisfied. This particular condition also has to be satisfied. See, if it was or, instead of and, if it was or, then any of these conditions, if you satisfy, you are eligible to incorporate an OPC. But here in the section, in the provision, we have it as and, right? Yes or no? And, meaning both this condition and this condition should be satisfied. Okay, let me give you a certain illustration. Okay, say for example, a partnership firm, say XYZ, XYZ and Co, wants to incorporate an OPC. Can it incorporate? Can it incorporate? No, it cannot, because it is not a natural person. Yes, yes. Okay. Now, Manichandana, she is an Indian citizen. Who is Manichandana? I am Manichandana. I am an Indian citizen. Now, I have stayed in India for, say, for example, 84 days. I have stayed I am an Indian citizen. I am a natural person. Yes or no? Now, I have stayed in India for 84 days. Now, will I be eligible to incorporate an become a member of OPC or to become nominee of the member of OPC? No, I will not be eligible because I have not stayed for a period of 120 days or more, right? Getting my point? Okay, one more example. Say Manichandana, but of UK, she's a UK citizen and she has stayed for, say for example, 365 days. Manichandana, but she is a UK citizen, but has stayed in India for a period of 365 days. Now, will she be eligible to incorporate OPC? The answer is no. The answer is no. Why? Why? Because I am not an Indian citizen. I am not an Indian citizen in this particular example. Clear? Clear, these 2 points clear. Only a natural person who is an Indian citizen, whether resident in India or otherwise, and has stayed in India for a period of not less than 120 days during the immediately preceding financial year. Okay. So one more question. Can say for example PQR company private limited, PQR private limited, can this become a member of OPC? Can this become a member of OPC? Can it become? The answer is no, it cannot, because this is not a natural person. PQR private limited, it is an artificial person. It is not a natural person. So it cannot become, it is not eligible to incorporate a OPC. This much is clear. Okay. Now what happened? What is that relevance of that whatever amendment that has taken place as children? See, this resident is there, na? So prior to this amendment, only a natural person who is an Indian citizen and who is a resident was eligible to become the member of OPC. Now they have inserted this or otherwise, meaning, the children, usually resident meaning it is 182 days or more. So if you have stayed in India for a period of 182 days or more, only then you are called a resident. Resident meaning basically if you have stayed in 182 days or more in India, then you are called a resident. Now, because they have inserted this or otherwise, and you also have to satisfy this particular condition of staying in India of not less than 120 days. Now, in a gist, if I have to tell you, this 182 days has reduced to 120 days. That 182 days provision which was there earlier has now reduced to 120 days. Basically, they have given you, even if you have not stayed for 182 days and if you have satisfied the condition of 120 days or more, still you will be able to incorporate, then you will be able to, you're eligible to incorporate a OPC. Clear? Getting it? Yes. That is not of relevance right now because see, They've given you the condition of 120 days. So whether you're resident in India or otherwise does not matter. Yes, 182 days, you stay in 182 days or you stay for 150 days, doesn't matter. And see, if you have stayed for 120 days or more, that is sufficient. 120 days or more, that is sufficient. Okay, now that 182 days does not have relevance, resident in India or otherwise. So that does not have much relevance right now. Okay, clear with this particular, the provision. Yes, everyone, can I move to the next? We'll just show you in this picture as well. Okay, so that it's easier for you. See, only a natural person who is an Indian citizen, only a natural person who is an Indian citizen, whether resident in India or otherwise. Is it of much relevance? No, it is not of much relevance because this is 182 days or more. Okay. Now, and has stayed in India for not less than 120 days during the immediately preceding financial year. So, this does not have much relevance, right? This does not have much relevance. So, only a natural person who is an Indian citizen, whether resident in India or otherwise, does not matter, because at least if you have stayed for at least 120 days in the immediately preceding financial year, so you will be eligible to incorporate an OPC. You will be eligible to incorporate a OPC, and you will also be eligible to become the nominee for that sole member of the OPC. Clear? Yes, right. Yes, ma'am. Good, very good. Okay, the next point. What is the next point? No person shall be eligible to incorporate more than one OPC, or become nominee in more than one such company. Okay, let's come here. Okay, see, one person. Oh, okay, see, one person, one OPC. One person, one OPC. Meaning what? No person shall be eligible to incorporate more than one. So, if I have incorporated one OPC, I will not be able to incorporate one more OPC. So, in my name, if I can become, I'll be able to incorporate only one OPC. So, one person, only one OPC. And or become nominee in more than one OPC. Meaning, say for example, this is Mani Chandana. This is me. Okay. I am a member of one OPC. Say, okay, we'll just write it down in a clear sheet so that you will understand better. Okay, wait. So this is me, right? This is Mani. Correct? I am a member in, say for example, one OPC. In one OPC, say for example, ABC. Okay, fine. Now, I am a nominee. In, say for example, XYZ OPC. This is also OPC only. This is also OPC only. Correct? Correct. Maximum I can become member in one OPC. I can become nominee in one more OPC. Right? Correct. Till here you have understood. That is what is given in your books. Yes? Wait, I'll just show you. No person shall be eligible to incorporate more than one OPC or become nominee in more than one OPC. Correct? Okay. Now, I am member in this particular OPC. Let me come back. Okay. I am member in this particular OPC and I am a nominee in this particular OPC. Right. Now, just imagine a situation where, where here there is, I am a nominee here in XYZ. So there is a member here. There is one more member here. Okay. There is one more member here. Now, imagine a situation where this member dies. What will happen now? I will become a member. Yes, by act of law, I will become the member of XYZ OPC as well. Yes or no? Now, see, I am a member of ABC OPC also. I am also a member of XYZ. Correct? But as per law, I can be a member in only one OPC, one person, only one OPC, I'll be able to become a member. So now what can I do? What can I do is, as per law, there is a time limit given. I will have to choose in which I will continue as a member and in which I will discontinue as a member. There's a period, there's a certain time period within which you have to decide, and you will have to decide which OPC you will be continuing as a member and which is the OPC which you will have to discontinue as a member, and you will have to inform the ROC. That is not there in your material, so don't worry. Whatever is there in your books is only that one person shall be eligible to incorporate, no person shall be eligible to incorporate more than one OPC or become nominee in more than one OPC. So, one person, one OPC, right? Correct? You can remember like this? Yes, ma'am. Okay. Next. No minor shall become member or nominee or can hold share with beneficial interest. Ma'am, what is this? What is this? What are they trying to tell? Here, see, there is a minor here. There is a minor. This fellow is a minor. Chotu. Yes, he cannot become a member. He cannot become a member of OPC. This is clear. Yes, he also cannot become a nominee of OPC. Yes or no? Nominee, you all know. He cannot become member. He cannot become nominee. Okay, he also cannot hold share with beneficial interest. He also cannot hold share with beneficial. Now, what do you mean by holding share with beneficial interest? See, children, this meaning, what the meaning of this particular, the sentence is that, say, there is a person, okay, there is a person, Mr. Raju. Let's just take an example. There is a person, Mr. Raju. He actually holds the shares. He holds the shares of whatever, the company, okay, company or OPC, whatever, okay. And now the benefit of these shares, are transferred to one more person, say for example, in our case, minor. Now, what are the benefits? Say for example, dividend. For example, dividend. Who is the holder of the shares? Who is the actual holder of shares? Mr. Raju is the holder of shares. So, in the books of the company, who is the shareholder or the member? Raju is the shareholder or member. Yes, correct. Now, but who is actually getting the interest of that shares? Who is actually getting the benefit of those shares? This particular person. This particular person here in our example, minor. So, he is getting all the dividend. Even though in the name, in the books of this company, Raju is the shareholder, all the benefits are being transferred to a different person, meaning holding share with beneficial interest. Here, this minor cannot hold such beneficial interest, cannot hold shares with beneficial interest. Artha aitu? Yes, artha aitu. Now you understood? Yes. Yes, ma'am. So Raju is the actual owner, and this minor, what is his beneficial interest? Whatever the benefits are arising from this particular shares are being transferred to this particular person. Can a minor hold share with beneficial interest? No, he cannot hold share with beneficial interest. So he cannot become a member, he cannot become a nominee, he cannot hold shares with beneficial interest. Clear? Simple, very simple. Yes, ma'am. Okay. Next, very important. Such company cannot be incorporated or converted into a company under Section 8 of the Act. Now, what do you mean by Section 8? What is that Section 8 company? What do you mean by the Section 8 company? See, children, Section 8 company is nothing but these companies are formed for charitable objects, basically not for profit organizations. These are formed to promote arts, to promote science, to promote dance or music, all of these, and to for some to benefit the society, basically to benefit the society. And the basic intention behind these companies are not for they do not work for profit. The basic intention is to do good to the society. They do not work for profits. So these kinds of companies are called Section 8 companies. You will be learning that as well in this Companies Act in your CA foundation. We will do that as well. So OPC. So now these OPCs cannot be incorporated, or once incorporated cannot be converted into a Section 8 companies. Getting it clear? Yes. Also one more important thing, come here. But though it may be converted to private or public companies in certain cases. There are certain conditions which need to be satisfied. If that is done, these OPCs can be converted to private or public companies in certain cases. So OPC cannot be incorporated or cannot be converted into Section 8 companies, but they may be converted into private or public companies in certain cases. Clear? Yes, ma'am. Next, such companies cannot carry out non-banking financial investment activities, including investment in securities of any body corporate. Ma'am, what is this? Children, non-banking financial investment activities. Do you know NBFCs? Do you know NBFCs? These are non-banking financial institutions, NBFC, meaning non-banking financial institutions. So what are these? Ma'am, these are nothing but, see, what do? Is they basically do everything which bank does, but they do not have banking licenses. These are, say for example, they lend, they take deposits, they lend money. Say for example, you would have heard this Bajaj Finance. Yes, Bajaj Finance. Also these M&M Finance. Yes, all of these, are these banks? Are these banks? No, but still they lend money, they take deposits, they accept deposits. Yes or no? So all of these come under non-banking financial institutions. So, so if you incorporate an OPC, these cannot carry out non-banking financial institution activities, meaning they cannot accept public. Obviously, when we are talking about financial institutions, we are talking about public money. Yes or no? We are talking about public money. So obviously, if you are accepting money from public, if you're giving loans to public, OPC cannot handle all of these. So OPC cannot carry out non-banking financial investment activities. Clear? Yes. Yes, ma'am. Also, including investment in securities of any body corporate. So this OPC cannot cannot purchase shares or debentures of any other company. Clear? Yes, here the member can be the sole. Here the member can be the sole member and director. Okay, I think we are clear with this. See, management is different, ownership is different. Management different, ownership is different. But still, can owners become the directors of the company? Can owners become the directors of the company? Is it possible? Is it possible? Yes. Yes, it is possible, because see, there is most of the students feel it very difficult when to understand this particular topic. Let me if you tell no, what about Mukesh Ambani? What about Narayan Murthy? See, uh, children, Reliance company, who is the owner? Mukesh Ambani holds shares, so he is the owner of the company. Also, he is the director of the company. He takes care about the business decisions, daily management of the businesses. He does take care. So he's also the director. He's also the shareholder. So a person, can he be a director, also a member? Yes, he can be. He can be, but there is a clear distinction between ownership and management. There is in a company form of organization, there is clear distinction between management and ownership, but a owner can become a director also. Clear? Yes, that is the same thing in any company form of organization, that is possible. Also in OPC also it is possible. Here the member can be the sole member and the director of the company. He only can manage the company as well, also being the member. But there is clear distinction between the two. Right? Everyone understood? Yes, OPC, one of the most important topics, right? Let's just revise all of these. Okay, fine. We'll do it in the chart or we'll do it in the book. Anything is fine. Or we'll do it in the book itself. No? Okay, come. Fine, this is done. Okay, one person company, significant points. Only one person as a member, right? Minimum paid up capital, there is no limit prescribed. Any minimum capital is allowed to incorporate an OPC. The memorandum of OPC shall indicate the name of the nominee. Yes, who shall, in the event of the subscriber's death or incapacity to contract, become the member of the company. So if the the main member dies, obviously the nominee will become the member of the company. Okay, such other person, who is that other person? The nominee, whose name is given in the memorandum, shall give his prior written consent. In which form? In form INC 3. INC 3. And the same shall be filed with whom? ROC, meaning Registrar of Companies, along with E Memorandum of Association and E Articles of Association. When, ma'am? During incorporation of the OPC, correct? Yes, such other person may be given the right to withdraw his consent. Who is the other person again? The nominee has the right to withdraw back his consent, correct? Yes, ma'am. The member of OPC at any time may change change the name of such other person by giving notice to the company, and the company shall intimate the same to the registrar. See, now once the nominee name has been given by the member, can he change it? Yes, ma'am, he can change it. He can change the name of the nominee. By doing what? By giving notice to the company, and the company in turn will intimate the ROC regarding the same. Fine. Any such change in the name of the person shall not be deemed to be the alteration, to be an alteration to the memorandum. It is not considered as altering the memorandum. Fine. This particular point, the next point, which, are you clear? Only a natural person who is an Indian citizen, whether resident or otherwise, and who has stayed in India for a period of not less than 120 days during the immediately preceding financial year shall be eligible to incorporate an OPC and shall become the nominee for such sole member of the OPC. Clear? Yes, ma'am. Next, no person shall be eligible to incorporate more than one OPC or become nominee in more than one such company. So, one person, only one OPC. One person, one OPC. Correct? Yes, ma'am. No minor shall become the member or nominee or shall hold shares of beneficial interest. This also clear. And such OPC, can it be incorporated as Section 8 companies? No, ma'am. Can it be converted into a Section 8 company? No, ma'am. Can it be converted into a private company? Yes, ma'am. Can it be converted to a public company? Yes, ma'am. Yes. Next. Such company cannot carry out non-banking financial activities, financial investment activities, including investment in the securities of other body corporates. Clear? Yes. Here, can the member be the director also, be the shareholders, or be the member also, be the director also? Yes, ma'am. Clear? Everyone clear? OPC? Easy? Yes, ma'am. Okay. Very good. Fine. So, coming to the next point, this you can read. OPC meaning one member company, private company in nature. So, OPC is a private company, yes or no? Yes. Encourages entrepreneurship and corporatization of business because it has company plus sole proprietorship benefits, right? Yes. Procedure requirements are simplified through exemptions. Does all the 470 sections apply to OPC? No, ma'am. There are certain exemptions. Next, separate legal entity and limited liability. Nice. Good. Good to go. Yes, ma'am. Okay. Next, children, private company. Next, let's discuss about private company. Right. What is a private company? A private company means a company having a minimum paid up share capital as may be prescribed and by its articles restricts the right to transfer its shares. Very important. Restricts the right to transfer its shares. Limits the number of its members to 200 except in the case of one person company. Obviously, in case of one person company, it's only one. Yes or no? Next, shall not be, prohibits any invitation to the public to subscribe for any securities of the company. So, there are 3 points. Private company, 3 points. What are these? Okay, the first one being means a company having a minimum paid up share capital as may be prescribed. Now, what is prescribed? Nothing is prescribed. What is prescribed? Nothing is prescribed. So, how much is the minimum paid up share capital? You can, your wish. You can start with 1,000 rupees. You can start with 5,000 rupees. You can start with 10,000 rupees. Your wish. Okay. So, private company means a company. Private company means a company having minimum paid up share capital as may be prescribed. What is prescribed? Nothing is prescribed. Okay. And by its articles, articles meaning articles of association. Okay. What is articles of association? You will see further. But it's nothing but an internal document of the company where it has all the rules and regulations. Okay, in that articles, it restricts the right to transfer its shares. So a private company, can it freely transfer its shares? Private company, no. It restricts the right to transfer its shares. It's not easy for the members to transfer their shares. Next, limits the number of members to 200. Limits the number of members to 200, except in case of one-person company, which is only one. Yes. Next, the third point is prohibits any invitation to the public to subscribe for any securities of the company. Meaning what? It prohibits an invitation to, obviously this is a private company. How will it allow to invite the public to subscribe to its shares? Yes, basically the prospectus is not allowed. What is prospectus? Is basically a document in which the company calls for shares. It will describe the company. It will have a short description of the company, also the details of the issue. Basically, it is a issue document wherein it contains all the details about the company and about the issue. It cannot issue prospectus. What? The private company cannot issue prospectus. It prohibits invitation to the public to subscribe for any securities of the company. The public are not allowed. The public are not allowed to subscribe to the shares of the company. So 3 points clear. Now how to remember? Children, just make a note of this. Yes, here is just a small mnemonic. Okay, you can write it here. T-I-M-E. T-I-M-E. Time, right? What did I tell? T-I-M-E. Time is the mnemonic. What is T? Transfer its shares. Transfer its shares. Restriction on transfer of its shares. Yes. Next, I for invitation to public. Invitation to public prohibits any invitation to the public to subscribe to its shares for any securities of the company. Next, M. What is M? Limits the number of members. Limits the number of members to 200. Now, what is E? E is the exception. Is the exception. What is that? OPC. OPC, that is only one. Right? Easy. Now easy. Yes, you'll have to remember. Private company, time. Private company, time. What is that time? T is for what? Transfer, restricts the right to transfer its shares. I for restricts the invitation to the public for subscription of its securities. Then M for limits the number of members to 200. E for except for one person company. Clear? This much is clear. Okay. Now we'll just go further with this particular point, that is limits the number of its members to 200. Children, in this 200, what are not included? See, provided that where two or more persons hold one or more shares in a company jointly. So if two or more persons have one or more shares, so me along with some other person are holding shares. Now we are considered as one. I along with some other person. See, this is me, and this is one more person. Yes, we both hold one share. Now we are two people, 1 and 2. Now, for the purpose of this particular clause, we are treated as one. We are treated as one shareholder. Yes or no? Yes, ma'am. Okay. Provided further that persons who are in employment of the company and persons who, having been formerly in the employment of the company, were members of the company while in that employment and have continued to be members after the employment ceased. Basically, what they're trying to tell you is, if the members are in the employment of the company, now that is not to be treated in for that 200 number. I am working in Infosys. I also have certain shares in Infosys. Now, I will not be counted for that 200 number. Clear? This is clear. Okay, the first one was this. The second one is, I am an employee of Infosys. Now, I also hold shares of Infosys. Now, I retire. I cease to be an employee of the company. I cease to be an employee of Infosys, but still I do hold shares of Infosys. Now, even I am not counted for the number of 200. Clear? This particular provision is clear, very easy. Yes or no? See, very easy. We'll read it again. Private company. Private company means a company having a minimum paid up share capital as may be prescribed. What is prescribed? Nothing is prescribed. And which by its articles restricts three things. What is that? Time. T meaning transfer of its shares. Yes, I meaning invitation to public for to subscribe to its securities. M meaning the number of members limited to 200. Exception is what? One person company. Done. So simple. For this limits the number of members to 200. Two or more person hold one or more shares in the company jointly. They shall be treated as one member. That's all. Provided further that persons who are in employment of the company and persons who were in employment of the company were members of the company while in employment, and after employment also they continue to be the members. After the employment ceases, they still continue to be the members. Will they be counted in that 200? No, they will not be counted for the 200 count. Clear? Simple? Very simple. Yes, ma'am. Again, private company significant points. What are these? No minimum paid up capital requirement. That's what we studied. Yes or no? Minimum number of members. Minimum number of members. It is 2. Maximum is how much? 200. That is what they have given here. Yes, in excluding present employees come members and erstwhile employees come members. Employee come members meaning employees also, members also. And this is erstwhile meaning past. Past employee come members. Clear, everyone? Yes. Right to transfer shares, is it restricted? Yes, ma'am, it is restricted. Prohibition on invitation to subscribe to the securities of the company. Is there a prohibition? Yes, there is a prohibition. Small company is a private company. Okay, that is this point. Okay, they have included here. OPC can be formed only as a private company. That is what I have told you. OPC and small companies are nothing but they are also private companies. Clear? Simple, no? Private company is simple. Yes, ma'am. Okay. Children, fine. Let's finish this. Okay. Next is small company. Next, we have small company. Small company, is it a public company or a private company? It's a private company. Yes or no? Yes. Okay. Let's read. Small company given under section 285 of the Companies Act 2013, which means a company other than a public company, which means a company other than a public company which has a paid up share capital of which does not exceed 50 lakh rupees or such higher amount which may be prescribed, which shall not be more than 10 crore rupees. And see again, and both the conditions to be satisfied. This condition should also be satisfied. This condition also should be satisfied for yourself to call yourself a small company. What is the second one? Turnover of which, as per profit and loss account for the immediately preceding financial year, does not exceed 2 crore rupees or such higher amount as may be prescribed, which will not be more than 100 crore rupees. Ma'am, ಏನು ಅರ್ಥ ಆಗಿಲ್ಲ meaning we have not understood anything. I know you have not understood anything. Right? Okay, children. So this is the definition which is given under section 2 subsection 85 of the Companies Act 2013. What is that? Basically, they are trying to tell you, what they are trying to tell you is paid up share capital. One point. The other point is turnover. See what they are trying to tell you. Paid up share capital does not exceed 50 lakh rupees or such higher amount which may be prescribed. This higher amount shall not be more than 10 crore rupees. Artha agilla. It's okay. Again we will come. Okay. Now, turnover which does not exceed 2 crore rupees. 2 crore rupees or such higher amount which shall not be more than 100 crore rupees. Okay. Now, children, I told you something. What is that? That is as may be prescribed. I have told you this word that I will explain it to you in small company. Yes, as may be prescribed. Which is prescribed? Prescribed. Where will this be prescribed? In the rules. This will be prescribed in the rules. Ma'am, what are these rules? Who makes these rules? What is this, ma'am? We don't know. See, children, you know how an act is being formed. You know how the act is being first there is a draft, there's a bill. We have discussed in Indian regulatory framework, everyone. Yes, first there is a draft or a bill which is then which goes to Lok Sabha. In Lok Sabha there is an approval, then it goes to Rajya Sabha. There also approval. After that it will go to the president. She has to sign, and after that it will be called an act, meaning they will notify it in the official gazette of India, and later it will be called an act. Now here you have the Lok Sabha, you also have the Rajya Sabha, and there is the ruling party, there is also the opposition party. So both the parties have to agree. Both ruling parties and the opposition parties have to, the opposition party is there to pass an act. Yes, they will oppose. All of this is there for a act to be passed. Yes or no? Yes. Now these rules, children, these rules are given by the central government. These rules are given by the central government, meaning the ruling party. The ruling party. There is no opposition involved. Yes or no? So it is very easy. It is very easy for the government to pass rules. Yes or no? Is it easy to pass rules, or is it easy to pass an act? Obviously, it is very easy to pass rules. So this Companies Act has in so many places you will see this as may be prescribed, as may be prescribed. Why? Why have they done this? If this provision is not inserted, then it is very difficult to amend the act. For amending the act, you have to go to Lok Sabha, you have to go to Rajya Sabha, the ruling party, the opposition party, everything. It's a very, it's very difficult. But when there are rules, it's very easy for the central government to pass rules. It's just one notification, just like this, they'll pass the rules. And that rules will be applicable to you all. Agree? Yes. See, when you study law is not just the act. Children, law is just not, it is not just the act. Law is a combination of the acts. It is a combination. You have to read act along with the rules and along with the case laws. Getting my point? Law includes act. It includes rules. It also includes case laws. All of this together forms the law. Getting my point? Yes, ma'am. So now that is the reason why you find as may be prescribed in this particular, not only in this particular act, in all of the acts. Okay, see, what they're trying to tell you here is paid up share capital does not exceed 50 lakh rupees. Okay, this is the thing which they have given in the act, or such higher amount as may be prescribed. So the central government, whenever it requires, as and when it requires, okay, it will change as may be prescribed. Now, how much has it prescribed? Now, the prescribed paid up share capital is how much? 4 crores. Now it is 4 crores. Now it is, children, how much is it? 4 crores. Here it is 40 crores. Now getting my point? Now, if you have to call yourself a small company, the paid up share capital of the company shall not how much? Shall not exceed 4 crore rupees, and the turnover shall not exceed, the immediately preceding financial year shall not exceed 40 crore rupees. Now what is this 2 crore and 50 lakhs? Children, this was there prior. Okay, this is there in the act. 50 lakhs, 2 crores, it is still there in the act. But for us now, right now, this particular rule is applicable. And according to this particular rule, it is 4 crore and 40 crore respectively, meaning this is for paid up share capital and this is for turnover. Getting it? So there is one more point which I have to make it clear. See, the central government has rules only till 10 crore. So it can increase paid up share capital, the small company definition, it can increase only till 10 crore. So now if it has to go beyond 10 crore, then does the central government has the permission? No, it does not have the permission to go beyond 10 crore, because that is what is there in the definition. If it has to be more than 10 crores, now the act has to be amended. And not only this, the central government has power only till 100 crore. It has only till 100 crore. Yes, if it has to cross 100 crore, now it is not possible with respect to the rules. It has to, now we have to amend the act. Getting my point? Getting my point, everyone? Yes, as and when necessary, the central government will pass rules and it will make changes wherever it is required. Right? Everyone? Yes, okay. Let's just read it here. See, small company significant points. See, a private company, a small company is a private company, yes, in which paid up share capital is not more than 50 lakh, which is given in the act. But as of now, it is 4 crore according to the rules. Yes. And sorry, children, this is not or, this is and. There is a hell lot of difference. You cannot use or and to your to your wish. It's not possible. This is law. You need to use, if it is and, you have to use and only. If it is or, you have to use or only, because and meaning you have to satisfy both the conditions, or meaning anyone. But here, small company, you have to satisfy both the conditions. It is and. Okay. And turnover not more than 2 crores. 2 crores is whatever is there in the act, and according to the rules, it is now increased to 40 crores. It is now increased to 40 crores. So if you have to call yourself a small company, your paid up share capital should not be more than 4 crore, and the turnover in the immediately preceding financial year should not exceed 40 crores. Clear? Everyone clear? Simple. And there are certain exceptions to this small company, that is a holding company. This clause shall not apply to holding company, subsidiary company, company registered under section 8, or a company or body corporate governed by any special act. Children, this holding and subsidiary, we will be doing it in the next class, so we will not be able to understand right now. Okay. And company registered under section 8, you know, it is a charitable company. So if you are a section 8 company, then you cannot be a small company. You cannot be a small company. If you're a section 8 company, basically, why small company, children? Why? What is the necessary, why was it necessary to give something, to have something called a small company? Basically, again, to relieve you with certain sections. Basically, few sections are not applicable to small company because it is still small company, na. So all the sections are not applicable to this small company. Okay, but if you are a section 8 company, can you be a small company? No. So if you are a holding company also, you cannot be a small company. If you are a subsidiary company also, you cannot be a small company and governed by any special act. Fine. Done. Understood, everyone? Yes. Okay. Fine. Next comes public company, the last topic for today. Okay, that is public company. What do you mean by public company? Right? Public company means a company which is not a private company. What is a public company? Ma'am, public company means a company which is not a private company. What is private company? You know what is a private company? Private company means a company in which there's a minimum paid up share capital which as may be prescribed, as in nothing is prescribed, and by which its art and which by its articles restricts what? Three: time. Yes, TIM and E. Yes, you know what is a private company. So public company is a company which is not a private company. So simple. Yes, and having a minimum paid up share capital as may be prescribed. Again, central government anytime can come up with rules here. Okay, but as of now, what is it? It is nothing. There is no minimum paid up share capital. You can start off with how much ever paid up share capital you like, right? Okay, fine. A company, provided a company which is a subsidiary of a company, not being a, okay, all of this you will understand once we complete the holding and subsidiary. Fine, that we will do it later. Okay, now let's see this. Public company significant points. Significant points. It is not a private company. Yes, everyone, you know. Shares, are they freely transferable? Yes, they are freely transferable. The shares of a public company are freely, so in a private company, are they freely transferable? No, there is a restriction. So here you can freely transfer your shares. Is there any minimum capital paid up, minimum paid up capital requirement? No, ma'am. There is no minimum paid up capital requirement even in case of public company. Next, minimum number of members, very important. What is the minimum number of members in case of a public company? In case of a public company, how much is it? 7. 7. Maximum, no limit. Maximum, no limit. In case of a private company, what is the minimum number of members? 2. What is the maximum number? 200, except OPC. Correct? Yes, this we will do it later. When you do this holding and subsidiary, you will learn that. Okay, fine. Okay, fine. Good. This is nothing. It just says that it is 7 or more persons. A company may be formed for any lawful purpose by 7 or more persons. Minimum number of members is 7. Where a company to be formed is to be a public company. Clear? Simple public company. This one holding subsidiary I have not done. You will not understand right now. Okay. And here this one particular point. Once we complete tomorrow, you will understand. Other than that, I think we are done. Right? All are clear? Yes? Very good. Let's meet in the next class.